Hi, this is Erica Maryland. I'm the founder of Perfect Legal Video, and I'm very excited to have with us today on the show attorney Jim Sorenson. He is a partner in the law firm Sorenson Van Leuven out of Tallahassee, Florida. And welcome to the show, Jim. What do you have for us today?
Hey, Erica, good to see you today. Thank you for having me. We're going to talk about litigation risks facing credit unions. As you know, we represent a lot of credit unions. That's a niche of our practice. And what I think is relevant is to talk about some of the litigation risks that are out there. We've spent the last couple interviews, we've talked more from the perspective of the regulators, the people who are charged with enforcing the laws and what they're focusing in on. And today I want to look more at from the consumer lawyer's perspective. What are the lawyers out there looking to pursue? And so right now, if you were to categorize kind of the biggest litigation risks that we see out there, and this is across the country, is lawsuits regarding overdraft litigation, claims involving the Fair Credit Reporting Act, claims involving the Telephone Consumer Protection Act, and claims involving repossessions. Those are the big ones that we see over and over again.
Oh, I know. And I love when we talk about these topics because it really brings to light a lot of the gotchas that maybe credit unions aren't aware of, and that unfortunately they become aware of in a big way and then end up costing them a lot of money later on because they are not prepared. So I think that's a fantastic topic.
Yeah, so it's you're exactly right. I think sometimes people are better aware of what the regulators are focusing in on, because the regulators will send out notices and information to the industry. Hey, this is an area of concern. This is an area of, that we're looking at. It's not always as clear what the consumer lawyers are looking for or what they're looking at. That's not always necessarily as intuitive or as clearly set out. And so that's what we want to talk about today.
So besides watching this video, how does one know what claims or actions that consumer lawyers are focusing on?
Yeah, well, first of all, someone has to have their finger on the pulse of the credit union movement, and that is something we try to do at our law firm, to stay up to date with what's happening in the industry. And of course, we get a lot of information just because of the various credit unions we work with, what we see and what we observe with our clients, and that gives us a window into what's happening across the industry. But in addition, you've got to follow industry news, the credit union information that is out there. And then, of course, you've got to do some of your own research. Some of this stuff is not as obvious or is not as well publicized. And that is something that we do. One of the things that I think a lot of people are surprised sometimes to find out is there are websites you can go to that are websites used by these consumer lawyers, where they are throwing out ideas. Hey, do you think we could sue a financial institution over this? And there's an open discussion about it, maybe with other lawyers, sometimes with consumers. You also will see websites where they actively are looking to, they're actively looking for people who bank at a certain credit union. So they'll say, do you bank at ABC Credit Union? And if you do, have you experienced this issue? And if so, give our office a call. And so when you go and you see those things, you get an idea of what the lawyers are looking for, who they're targeting, what specific facts they're looking for. And then from that, you can usually extrapolate and figure out the law or the area of the law they're looking to take advantage of or to exploit, or they believe that law has been violated.
What comes to mind, and now that you mentioned that, I do see commercials like that. I see billboards, and it just reminds me of like just somebody sneaking up on a hornet's nest and with a stick and just hitting it and just getting everybody angry and out there and ready to attack. And
Yes.
so, I mean, that cannot be a great thought for some of your clients who are just trying to run their business honestly. They've got these troublemakers out there that are just out for a buck, and they are trying to get the masses involved in attacking the businesses.
Yes, and some of these are always not tried theories. They're very nuanced areas of the law, and they're looking to quote unquote make new law, to take a unique fact pattern and say, well, fact pattern A may not violate the law, but if you change it just a little bit, now you're in violation of law. A lot of these are very technical, very gotcha type things. And sometimes they have to do with emerging technology or emerging services in the financial service industry.
I mean, and that's amazing. So I'm glad that you're talking about this today, and that's very interesting for everyone to know. So I heard you mention overdraft litigation, which I've never heard of before, but like everyone, sometimes you don't have enough money in your account, or there's like checks that are supposed to go in and you've got bills that are being paid automatically, and sometimes you make that mistake and all of a sudden you have all these tiny charges for $15 or $20, but they're charging like a $35 fee for every single one that went over. Tell us more about the threat to the credit unions.
Yeah, so the overdraft is exactly what you described. It's the deposit account situation. Typically, you think of a checking account, whatever that may be called, that people are accessing, and it's not so much by check anymore. It's more debit cards and, like you say, bills that are set to come out of your account at particular times, whether it's a Netflix bill or a Amazon bill, or take your pick, right? All these conveniences we have. And what happens from time to time is people overdraw their account by accident, and so the overdraft program is simply a way that, instead of that debit or that charge being denied, the credit union or financial institution allows that charge to go through. And in regards to that, there is now a fee associated with that. So most financial institutions, when you overdraft your account, there are certain fees you incur. And the litigation all revolves around that issue. And what you'll see is that the litigation basically breaks down into three areas. It breaks down into, did what the credit union did they violate a regulation called Regulation E? It's a federal regulation that governs overdrafts. You'll see claims brought that the account agreement itself was violated, or they're arguing that there's a specific state law that the credit union or the financial institution has violated. So it's very technical, and a lot of times it turns on unique practices of when and how fees are charged for certain items, and do the disclosures that the consumers got when they signed up for the account, do they match what they're doing? What a financial institution is supposed to do is explain in plain English how and when those fees will incur. And so if it's not necessarily clear, that can lead to claims, and some of these become very, very technical in terms of the facts and the situation. But those are what these claims involve.
Oh, I mean, that is really interesting, and it does sound nitpicky and technical, and something that people maybe didn't think about before as they're running their credit unions. So what can be done to mitigate this kind of risk?
Yeah, so the mitigation of this risk, first of all, the credit unions need to review the account agreement, the account documents, with a knowledgeable lawyer, and make sure that what it says the credit union is doing, that's what the credit union is doing. Sometimes these documents were written a year, 2 years, 3 years ago, and someone comes along within the credit union and makes a change, and the documents themselves are never updated. So those documents need to be looked at and considered, and need to be reviewed on some regular basis. Do our practices match what our documents say? The other part is the credit union can consider arbitration clauses. This is a big issue in this area, but do we require that if a claim arises, it goes to arbitration as opposed to the courts? There are several things to consider in choosing arbitration clauses. We could spend an hour just talking about that. But that is one of the tools that may be available, and there's certain things they're going to need to talk to a lawyer about and consider before they do that. Two is just ensuring information is consistent across all the mediums, that the way a charge is incurred does not change whether it's a debit or a check or an automatic payment, that they're all treated the same. And then, of course, they just need to look at how their fees are being charged and whether fees should be restructured. Sometimes clients handle fees in a way that raise more questions and are questionable under the law, and those fees or the way the fees are charged need to be restructured. So those are all things that need to be done to mitigate risk. And of course, the credit union needs to have someone who's working with them who understands the risks and understands the laws and the lawsuits that are out there, these theories that lawyers are bringing, to be able to protect them from these risks.
One of the things that I heard you mention, the Fair Credit Reporting Act and the litigation risks involved there. What types of claims are you seeing that are brought against the credit unions when it comes to this particular act?
Yeah, so the Fair Credit Reporting Act, or sometimes as we will call it the FCRA to shorten it, this continues to be a hot topic of litigation. Whereas in the difference between this and the overdraft litigation tends to be class action lawsuits. They tend to be a big one. So when a credit union gets sued, the lawyer bringing that claim is trying to seek a class action on behalf of all the other people who've overdrafted their account in the last year or 2 years or whatever that time period is. The Fair Credit Reporting Act claims tend not to be class action. They tend to be one claimant, one claim, but the volume of them is much higher. There's more of these types of claims filed than the overdraft, but they tend to be individual claims. So whereas the others may be striking the hornet's nest, and these tend to be death by 1,000 cuts, if you will. If you're violating the law or you don't have good procedures in place, you're going to face a lot of these claims, and each claim by themselves may not be big dollar, but over time, they start adding up. And of course, you've also got the time and expense of just dealing with the claims, not just even to settle them. So what we see here are really three variations of the claim. One is that the consumer report was impermissibly accessed by the lender. So what this has to do with is a lender has looked at a consumer's credit report, and when the consumer goes and pulls their credit, they get a free credit report, or they have some credit monitoring program that they're part of, they get an alert, hey, ABC Credit Union pulled your credit. And they say, well, wait a second, I don't remember applying for credit at ABC Credit Union. And so what they will do is they'll send a letter to the credit union saying, my credit report shows that on January 15th, you pulled my credit. Did you have permission to pull my credit on January 15th? And there's a lot of reasons why credit is pulled. But under the law, in order for a lender or an employer or an insurance company, there's a lot of different entities that use credit reports. But in order for a credit report to be pulled, it has to be what's considered a permissible permission under the law. It has to fall within a certain category. And so we're seeing a lot of claims now being brought where the allegation is, hey, I didn't apply for the loan. I didn't give you permission to pull my credit. And it may be that it could be something like identity theft. John Doe didn't apply for the loan. Someone impersonating John Doe applied for the loan. Or it could be that they applied for the loan, but there's not a documentation to show they applied for the loan. or it could be some other factual situation. So we see that. The other thing we see is information provided to consumer reporting agencies that's not accurate. So here the allegation is the credit union is giving inaccurate information about my credit. They're reporting the wrong loan amount. They're reporting the wrong payment date. They're reporting the wrong payment amount, or they're reporting that I paid late when I didn't. And then the third is failure to conduct a timely investigation of a dispute. And this is simply when I dispute my credit, does the credit union handle that in accordance with the law? So the claims are brought one of those three, maybe sometimes a combination of more than one, but that's what we're seeing.
Wow. I mean, it sounds like there are a lot of things to look out for. What are some of the things that the credit union can do to avoid these types of claims?
Well, I think the first issue is well-drafted policies and procedures. I mean, Fair Credit Reporting Act is one of these very technical areas of the law that has a lot of gotchas. And so a well-drafted procedure will avoid or eliminate some of those issues. And this is something that both the regulators have stressed, and given the fact that consumer lawyers look at this to me is just one of those areas that credit unions should make sure, are our procedures up to date? Have they been thoroughly prepared, and do they cover the common issues we need to cover? Second is an audit. You need to look at what's actually happening at the credit union. When we get a dispute, are we timely handling those disputes? Do we accurately report information? Are we documenting when and how and why we pull credit reports? And then training is part of that. And then lastly is more of a technical concern, but it does come into play. When a credit union is doing credit reporting, they're doing it under what's called Metro 2 coding. That's just a fancy name for the computer coding that goes on between the credit union and the credit bureaus or the consumer reporting agencies. And what we've noticed sometimes is a credit union will have a wrong reporting because they're not using the latest software, and it's creating this technical violation. It's nothing intentional, but because computer programs haven't been updated, they're not reporting correctly anymore. And so that's something that is more technical in nature, but can cause these violations of the law. So something to look at.
Yeah, and a lot of people don't think of this, but when you have a problem like that is happening over and over again because of computer glitch, or because you had a process in place, but a human being stopped doing that process. And so the mistake is being made 10, 20, 30 times, hundreds of times a day. The problem can become quite large and quite costly if all of those people end up suing the credit union.
Yes, no, exactly. And so these are all ways to limit those problems, or to eliminate those risks.
Now, we've touched on this before, and it's like anything else. There are a lot of phone calls sometimes being made, and if something's being done wrong, that can accumulate exponentially as a problem for the credit union. So when you were talking about the Telephone Consumer Practices Act, what issues have you seen that are coming up when the credit unions are using the telephone or hiring other people to use the telephone for them?
Yeah, so the claims here, or the concerns here, really have to do with consent. And what we're talking about here, and where most of the claims are brought, is these are claims involving creditors making calls or sending text messages to a cell phone or mobile number of the consumer. And the issue under the law, under the TCPA, is does the creditor have consent to make the call? Or if they had consent, did the consumer later revoke the consent, and now calls are being made after consent was revoked? It all revolves around the idea of consent. And the TCPA says in order to contact the member or the consumer on their phone, you have to and again, it's mobile phone, cellular phone. In order to contact them on their mobile phone or their cellular phone, you have to have consent. The consumer can revoke that consent. And if they do, phone calls have to stop. And so what we're seeing is claims being brought that calls were made and the consumer either had never given consent or has since revoked that consent.
It's not always their fault that this is happening. And, sometimes it is. Sometimes the right notation wasn't made in the system. And that's just a click of a button. And when you're making a lot of calls, that is an easy mistake to make. I used to work in the phone industry, so I know how easy that is to mess up. So can you tell us, how can they protect themselves from this sort of thing happening?
Yeah. So I think, first of all, you're exactly right. Human error. It's, it's going to happen. We know as humans, we aren't perfect. We all can make mistakes. And so, the best trained employees, the best intentioned employees are going to have that off day where they make a mistake. So you want to have procedures and policies that limit those mistakes, or at least limit the consequences of those mistakes. And so you have to have well-drafted procedures and policies in place. You need to do some auditing. Are the practices and procedures being followed? Again, we've talked about this already, but it's the same idea. And then training again. The other two things that I think, besides good procedures, auditing, and training, is the credit union needs to be aware of when they implement new technology or services that impact TCPA risks. I'll give you an example, something I saw at one of my clients. So there's always these new technologies that emerge. And so one of my credit union clients was looking at the issue of keeping the member keeping the car insured. So when a credit union lends money on a car, one of the things that the loan documents require is that the borrower maintain insurance on the car, so that if the car is in an auto accident, there's insurance to pay for repairing the auto, or if the auto gets totaled, there's money to pay the auto loan off. And that's part of the contract, if you will. But one of the issues that has to be done is, how do you track insurance? And if you determine that your borrower, John Doe, has not maintained insurance on their Honda Accord, how do you notify them of that? And so the old way of doing it was letters would go out. You would have a series of letters go, and it would say, hey, Mr. Doe, we believe you no longer have insurance on your Honda Accord. Can you provide us proof of insurance? And of course, if he ignores that, a second letter went, and then a third letter. And as we know, mail's not always effective. A lot of mail people don't open, they don't read, they throw in the trash. So one of the newer technologies or newer ways that this is done is using outside vendors who will send text messages to consumers. Hey, we need proof of insurance. Click here to update your insurance. And it's a great little convenience, right? Instead of me having to call someone, I now can take my cell phone, click a link, and go to a screen on my web browser and input, oh yeah, I have insurance with State Farm. Here's my policy number. Here's the date, or whatever the information that needs to be put in there, and I'm done. But what happens is that's a text to a consumer phone, right? And so if the consumer has said, don't use my cell phone, and now over here we're using the cell phone, you violate the law if you don't have consent. And it's kind of this department doing one thing, and now this other department at the credit union doing another thing, and the two aren't talking and realizing that this new way to communicate with the member is creating this potential problem. So it takes a lot of coordination when new technology, when new services are put in place. Are we following the law? Then again, we've already talked about this, but they need to consider arbitration clauses in the loan documents. That's another way you can limit the risk. There are several things you have to consider before you do that, but that is one way to limit the risks.
Strategy when you're running a business is so key. And if I had $1 for every time I heard of a business the one hand doesn't know what the other hand is doing, and mistakes are just being made across the board, I'd be a millionaire just on that. So, I mean, I think it's great because I know that you help train the credit unions, you help make sure that those policies and procedures are not only in place, but that they are also checking that they're being followed on a regular basis, because it's very easy to fall out of a habit. If it's a little bit more work, they don't own the credit union. Not everybody cares. It's working in a lower position. It's very easy for those mistakes to be made, and they don't realize even how much trouble it's going to cause later on for their employer. So let's talk about repossession, because there's a lot of different types of repossession. I feel like we've done that topic for a couple different reasons. We did it for the SCRA a couple weeks ago, and now we're going to be talking about it today. What are some of the risks and problems that credit unions need to watch out for when it comes to general repossessions?
Yeah, so repossessions is one of those areas that continues to be an area that is ripe for litigation. And it's been that way my whole career, my 25 years of working with credit unions. It's been that way. Repossessions always are risky. And, if you think about it, it makes sense, right? You take someone's property. Sometimes people will admit, yes, I didn't pay my loan, and I realize I signed a contract, and if I did not pay, you were going to take my property. But a lot of times people are upset. There's all sorts of reasons they didn't pay. They've fallen on hard times, and now they've lost their car. And, as Americans, we love our cars. And so that leads to a lot of emotion. People are more prone to go and see a lawyer or to research their potential rights under the law. And as a result of that, repossessions are always up there. And because repossessions have so many technical aspects that we've talked about, so many laws come into play, this continues to be a high risk area. And the claims are generally, the risks of the claims that come into play is failure to comply with applicable laws. That could be state laws that apply to repossessions. It could be federal laws like the SCRA dealing with active military members, or it could be other federal laws that come into play. And these claims can involve issues such as was proper notice given before or after the repossession. Different states have different notice requirements. So what the notice you have to give in Florida can be different than the notice you might have to give in Georgia or Texas or California. And then again, there are specialty laws that come into play like the SCRA and other laws that impact repossession. So these are the claims we're seeing and we continue to see.
I mean, and that's too bad when that happens. I mean, nobody wants to take property back. They don't want to do that, but it is necessary sometimes, especially when you have everything going on in the world that's going on today, where people don't have as much money as they used to in a lot of cases, and they do need to try to change the way they're spending their money, and maybe get something that's more affordable for now. But when this comes up and somebody does want to sue, what are some of the things that a credit union can do to avoid this from happening and having to go through this whole process of going to court?
Well, I'm going to sound like a broken record here, but it's the same things we've been talking about. I mean, one, there are policies and procedures. Are there policies and procedures up to date? That's a big one. Are your repossession letters and forms up to date? Like I mentioned, different states have different notice requirements. These are usually statutory requirements that the notice has to go out at a certain time or has to have certain things in it. And that can differ from state to state. So what a credit union in Texas has to do is going to be different than a Texas credit union in Florida. So are we using compliant forms? in our department. And, those are easy things to have a lawyer look at your forms. Are they up to date? And when was the last time they were reviewed? Is our procedures up to date? Audits of the repossession files is a big deal. Again, those audits can be internal audits, meaning someone at the credit union goes and looks at a repossession file and says, did we do everything right? Is there a breakdown in the process? This isn't, you don't look at every file, but you look at several files to get an idea. Are we doing everything we're supposed to be doing, everything we've trained our employees to do? And then training, where there are breakdowns in processes, are we training? Are we trying to correct those processes? Are we being proactive? Those are all the things that need to be done. And this is a combination that the credit union, some of these things are things the credit union can do in-house. They don't need someone outside to help them. And then in other cases, they do need outside help. Are our forms in compliance? That's something that certainly a lawyer should look at. Are our procedures in compliance? That's something a lawyer should look at. The audits, those can be done internally, or you can engage someone like our firm. We do that for our clients. And then the training. Whether or not you do the training internal, you should certainly have legal feedback on whether the training is up to date and tracks the current law and certainly the laws in the state where you're practicing or you're repossessing collateral.
I mean, that makes a lot of sense. And I know that your clients are so lucky to have you, because you save them hundreds of thousands of dollars every year on frivolous lawsuits and, just making sure they have the right processes in place. So I know that that's really what helps you stand out from your competition is, the training and making sure that, an ounce of prevention is worth a pound of cure.
Yes, that is our focus, and why I enjoy taking time to do these interviews and hopefully educating people and warning people and giving them an opportunity to avoid these issues well in advance of them happening.
That's the best way to do it.
Yep.
So I want to thank you so much for coming on today. Really appreciate all of this fantastic information, and looking forward to hearing what you have to talk about in the next couple of weeks.
Well, thank you for having me, Erica. I appreciate it.
Okay, thank you. Bye-bye.